Hi, I'm David Vicknair with Scott Vicknair Injury Lawyers, and the question we're tackling today is what are 5 factors you should consider when you analyze a potential wrongful death claim on behalf of a family member? Number 1, who has the wrongful death claim? So if you're analyzing this, unfortunately, you have a terrible situation in your family where you believe somebody has died as a result of negligence, gross negligence, maybe the intentional negligence of another party, whether it be another driver, a company, a rig explosion, something left on the ground which led to a significant slip and fall which may have caused a serious injury resulting in death. So we've seen wrongful death claims that range the gamut from car accidents where somebody died immediately, very tragic situations where they burned alive, situations where somebody may have drowned, situations where somebody's in a car accident, they have initial injuries which later lead to death. All of these cases are emotionally traumatic and horrible, and the first thing that everybody always starts at when deciding whether or not there's a hospital, defendant, or some third party who's potentially responsible for that wrongful death is who has the claim, and it's all governed by Louisiana Code Article 2315.1, which gives the class of survivors who hold the wrongful death claim on behalf of the decedent, the person who's died. And it starts with the surviving spouse and children, if there are any. And after that, if there is no surviving spouse and no children, then it goes to the parents of the deceased, the decedent. And if the parents are no longer alive, then it goes down next to the siblings. And so there's 5 or 6 different pieces of 2315.1 which govern the class of survivors. It first starts with the spouse and children, and if there are no spouse and children, then it goes next to the next layer. It is exclusive, and that means that they don't collect together. The children and the surviving spouse have individual wrongful death claims. Second consideration is, do you have to open probate, or in Louisiana what we call a succession? The answer is no, and that's a very misunderstood concept in wrongful death and survival claims, is that a succession does not need to be open. They do not have to have an administrator or any administratrix appointed in an estate in Louisiana to hold the wrongful death claim. It is held via statute. There have been multiple cases in Louisiana over the last 10 years that have made this clear, one of them being the Rainey decision from the First Circuit Court of Appeal, which made clear that the survivors of the deceased person hold that right via statute. So in a hypothetical, if somebody would pass away and they left everything to their sister, but they had kids and a surviving spouse, but their sister got everything in their will, the wife and the surviving kids still hold the right for a potential wrongful death claim to the exclusion of that deceased person's sister. She has no right to the wrongful death or survival claim just because she was inheriting everything through the succession, through the person's will, through probate. The right is statutory, not something that the decedent, me, you, anyone who is wrongfully dies as a result of the negligence of another, we can't inherit that to someone other than what the statute provides for. Third, what are the damages in a wrongful death claim and how are they assessed? In a wrongful death claim, wrongful death, not survival, we'll get to that in a second, but wrongful death damages typically focus on loss of companionship and loss of support. So for example, a wife who's left behind after a husband dies in a terrible car accident, she would have a claim for his death, and part of the testimony and evidence that the trier of fact, whether it be a judge or jury, would hear is how long had they been married? How much did she financially rely on her husband for support in the household? What other household support did he provide her in living support on a day-to-day basis that she has lost as a result of this horrible incident? How has that affected her emotionally, mentally? How has the loss of that husband affected her day-to-day life? So all of that is testimony and evidence that the trier of fact would hear in assessing the damages for a wrongful death claim. Prior to COVID, wrongful death damages typically were a lot smaller than you might think, and being upheld by courts of appeal anywhere from the $150,000 to $250,000 to $300,000 range on the lower end. And courts of appeal did not reverse those and say they were an abuse of discretion being too low. And so there certainly were bigger wrongful death damages that trial courts would give, but there were a lot of them that would surprise me when I would research this before before COVID happened. And what we've seen is the reverse after COVID, is we've seen wrongful death damages go incrementally larger. And I think it's part of a larger, personally, societal trend towards valuing life and valuing each other's lives more. And we're seeing that play out in juries when they try wrongful death claims now. So now they can be a lot more valuable, and there are some upper limits that the Court of Appeal in Louisiana would reduce down or remitter, but typically it's all dependent on the facts and evidence of each individual case. Fourth, do you have a survival claim? A survival claim is distinct from the wrongful death claim, meaning that period of time where the decedent was conscious and suffering prior to death. So in a drowning case, for example, you would need to elicit medical and expert testimony about the typical time of duration that the decedent or the deceased person was alive prior to their drowning. And what did they feel during that period? How were they suffering, if at all, if you were to be entitled to a potential survival claim there? The same thing would happen in a wrongful death claim where someone died by the worst way you could die, which is burning alive. Would be expert testimony establishing a period of time from the incident until the deceased person died, and understanding how long that period of time was, how did they feel. And so the survival damage claims can typically dwarf wrongful damage claims if somebody's been in a horrific incident where they burned, drowned, or had one of these very severe and traumatic spurts of pain prior to death where they were consciously suffering. And a lot of times those damages can be more than the wrongful death claim damages, but they're not always necessarily present. You still have to meet your burden of proof and show there was a duration of time prior to the death to get past any type of dismissal motion, which would dismiss any survival damage claims. Fifth and last is, what are previous awards for both wrongful death claims and survival damage claims, and would your award be held? So we discussed earlier some quantum, what we call quantum, which is just looking at prior awards in other jurisdictions across Louisiana. Any experienced injury lawyer is going to do this. They're going to have a database just like we do, where we research prior awards going all the way back to the 1960s. Somebody comes in here with a shoulder injury and a shoulder surgery, we know what shoulder awards have been provided in the last 40 years in the 1st Judicial District Court, in the 15th Judicial District Court in Lafayette, in the 19th Judicial District Court in Baton Rouge, in Orleans Parish District Court here in New Orleans. So we're aware of and examine all of these prior awards to determine what is the quantum of that specific modality or that specific injury. And so in wrongful death and survival claims, like I mentioned earlier, they could run the gamut. You see wrongful death claims that were awarded somewhere between $100,000 or $150,000 being upheld at appeal as not being abusively low. And then you see wrongful death awards being awarded up to $5 or $6 million, which are being upheld at the Court of Appeal as not being abusively high. So the wrongful death claim damages could be anywhere in that 150 to $5 million range to generally be upheld by courts of appeal in Louisiana, depending upon the facts and circumstances. Some, depending upon the facts and circumstances, may be even upheld over $5 million. And part of that analysis is how many claims are there. If you have 4 kids and a wife who have been unfortunately left behind by a father who was killed, and they each get $5 million, that would probably not be found to be abusively high for a wrongful death award to each individual claimant who has that claim. These survival damage claims I mentioned earlier are also highly dependent upon the facts and circumstances. And in the one context, we talked about somebody who would horrifically burn alive. It's the worst death possible. Nobody could ever come up with a more painful and agonizing death. And so if you establish through expert testimony and competent evidence that a sibling burned alive, you could expect that to be a massively large, potentially financial award that a court of appeal probably would not reduce up to $50, $60 million. But not that any trial court would necessarily give that much money on a survival claim, but it's possible. And, you know, on the high end of what the Court of Appeal would look at is this is the worst possible way to die, and what are other similar awards that have been provided and upheld in situations where there have been survival claims and somebody burned alive. And 2, on the low end in survival claims, if it was one of the less, it's a quick, let's say it's a car accident, you don't have a drowning, you don't have somebody who burned alive to where there's been 2, 3, 4, 5, 6 minutes of conscious pain and agonizing suffering, but somebody who maybe you could prove lived 10 or 15 seconds before they passed. That survival damage award probably would not get as large as the monetary value from the jury and or the Court of Appeal upholding it as a claim where somebody who burned to death, but was conscious and suffering for 10 minutes. So the survival damage claims are no different than wrongful death claims, which are truly no different than injury claims where somebody has not luckily lost their life. They're all fact dependent upon the injury, the suffering, the impact on the family, and all those things are derived from medical testimony, from fact witness testimony, family members and witnesses, as well as from the medical records and evidence as applicable in each particular matter. So if you've listened this far, I'm sorry that you may have been interested in this because you may have a family member who has tragically died and you have lost and you're analyzing whether or not there is a wrongful death claim. We're really sorry for your loss. But as you could probably deduce from the last 8, 9, or 10 minutes of me discussing this, we've unfortunately dealt with a lot of these over the years. They're some of the most emotionally charged and difficult cases for my staff and myself to handle because we put ourselves in the shoes of our clients, the surviving family members, and we see the traumatic nature of what they're dealing with after the loss of a loved one or a close family member. And so it's very difficult, but it's important that you have objective and educated counsel who has done and handled a lot of personal injury claims which involve wrongful death and survival claims and understands the different modalities and types of treatment and providers and experts that need to be involved in your claim to support a survival claim, for example, to establish what were they suffering during that discrete period of time after the incident and prior to their death. And that's something that we've unfortunately had a lot of experience with over the last 14 years at my law firm. If you would like to discuss this with us confidentially, we provide free consultations. You can give us a call. We love to talk to you and your family and try to give you at least some initial direction on which way you may or may not be able to go with a potential wrongful death claim. How long do you have to file a claim after an accident? The answer is as soon as possible. So let's get into it. While Louisiana law may say